All rise, veuillez vous lever. Please be seated, veuillez vous asseoir.
Good morning again, Council. Mr. Jacobs, you may want to continue, please. Thank you.
Merci, Madame la Présidente.
Professor Jacobs, thank you, Your Honor. I'd now like to move to the next point, namely our analysis of the weakness of the prosecution's case, namely the massive use of hearsay. The analysis underway of the prosecution's case reveals that a great deal of their allegations are based on witnesses who are merely reporting hearsay, often anonymous in nature. In particular, in our responses to applications from the prosecution for under Rule 68, that all the witnesses for which the prosecution has asked, that previous statements been admitted, these witnesses are relating hearsay, mostly in relation to important elements of their testimony. Here is quite a striking example, namely the alleged incident involving a minibus at PK9. For this particular incident, the prosecution claims that it is relying upon 8 witnesses. Yet an analysis of the previous statement of these witnesses shows that in actual fact, none of them were present during the alleged incident, and all of them are reporting hearsay. In addition, for the first 2 witnesses, P0491 and P0529, we have demonstrated before the break that their statements were based entirely on hearsay coming from third persons who in turn were reporting more hearsay. As for the third witness, the statement given by P0510 is also made up of several items of hearsay, especially, in particular, I have to stress that he never was present when the alleged incident occurred. He merely provided the prosecution with a number of photographs saying that they were photographs of alleged victims of the alleged incident. P0510 did not even take the photographs himself. None of the photographs are dated, and we have no metadata in relation to these photographs. In the case of one photograph, it actually is specified that the metadata indicate that the photograph was altered on the 16th of July 2013 at 11:26. Finally, the only link between these photographs and the minibus incident is the witness himself, who was not present when the incident occurred, nor who took photographs. He says that the bodies were apparently those of people who apparently died during the said incident, the so-called PK9 minibus incident. These are the photographs that were shown during yesterday's hearing by the prosecution to say that saying that they were photographs of the alleged victims of the minibus incident, whereas in actual fact, they have no knowledge about any such thing because they have not investigated. Moving on to the fourth witness, P1808. This witness also relies on anonymous hearsay. Quote, "That's what people were saying," unquote, says the witness. Quote, "People from the neighborhood told me about that," unquote. Quote, "She told me this story," unquote, according to the witness. The fifth witness, P0358, was not a direct witness of the incident either. P0358 actually stated that he heard about the incident on the radio. The sixth witness, the prosecution makes reference back to the previous statement of P2573. Once again, the witness was not present when the alleged incident occurred, but on the contrary, heard about it from another person. As for the seventh witness, P0834, this person relies exclusively upon an element of hearsay. That is the only information that he provides, something that someone else gave to him. Finally, the eighth witness, P0291, in his previous statement, he never speaks of the alleged incident. The prosecution's procedures is as follows when it comes to the alleged minibus incident. Since in actual fact there are no direct witnesses of the alleged incident, the prosecution has hearsay, often anonymous in nature, which it uses to corroborate information with new hearsay, often coming from the same sources, yet the accumulation of evidence with little probative value does not, if you put it all together, that does not magically turn it into a solid piece of evidence. Surely to cover up all this hearsay, the prosecution never says in their brief that an allegation was based on hearsay, for example, by using the conditional tense in French. The prosecution always presents hearsay as the absolute truth. If the prosecution brief were to be rewritten using the conditional tense for hearsay, this brief would be for the most part, written in the conditional tense. In any event, once again, this is not how allegations are proven beyond reasonable doubt. I'd now like to move on to the next point, namely the lack of forensic evidence. Of the 52 prosecution witnesses who are being brought to court as crime-based witnesses, we see that only 7 of them will be providing forensic information. In other words, the prosecution does not have forensic evidence for 87% of their crime-based witnesses. No forensic evidence contemporary with the alleged events. No subsequent forensic evidence established after the alleged events. Thus, no forensic evidence to attest to the alleged injuries suffered by the witness at the time of the events. Correction, injuries allegedly suffered by these witnesses, in the plural. For a number of witnesses, the prosecution has merely taken photographs of scars. All the same, it's crystal clear that a photograph taken years after the alleged events proves absolutely nothing. The injury could very well have been the outcome of another event before or after 2013, and there's nothing to say otherwise. Similarly, administrative documents such as a Civil Status Act, a nationality certificate, a copy of an ID card or a voter's card, such documents cannot be considered forensic evidence and cannot be considered to be sufficient evidence to demonstrate the reality of a death or injury, or even less their cause. Finally, it is interesting to note that at no time the prosecution bothered to question the person who issued or signed such documents in order to authentify the certificate or understand its scope. So the prosecution did not carry out its duty to investigate, and it's not provided the defense or the chamber with any information that would allow one to authenticate the forensic information that they have presented. Under these conditions, it must be observed that the prosecution has made no effort to demonstrate, on the basis of solid, reliable forensic evidence, the very reality of the alleged injuries allegedly suffered by the witnesses, even though such a demonstration even though this should be the starting point of its demonstration. The prosecution has forgotten its duty to investigate independently, autonomously about what actually happened, and the prosecution rather preferred to take their witnesses at face value. And now the prosecution is asking the chamber to believe what they are saying at face value. This being the case, the prosecution has not met its obligation to prove its case beyond reasonable doubt. I'd now like to move on to the next point, namely the insider witnesses. Yesterday, during the hearing, the prosecution told the court that they intended to rely on several insider witnesses. Yet, one merely has to read these witnesses' previous statements to see that they could have all kinds of reasons for not being entirely honest during their testimony. In particular, they may attempt to hide their own role, or they may misrepresent their role. be it people who claimed that they were part of the Seleka at the time, or people who continued to play a role within the state after December 2013. If we look beyond this credibility problem, it's important to realize that by making mention of insider witnesses, the prosecution is trying to give the impression that they have first-hand information from the inside about key issues, such as the existence of a state policy or organization, or the operations of state institutions at the time. But nothing could be further from the truth. By the end of the trial, it will be simple to observe that the so-called insider witnesses are in actual fact low-level junior people who are relating hearsay and who are absolutely not in any position to provide the slightest amount of useful information to support the prosecution's allegations. For example, regarding policy, a prima facie analysis of the prosecution's case shows that the prosecution will not be providing testimonial evidence that will allow the court to examine the existence of a policy. In fact, if the prosecution wanted to demonstrate the existence of a state policy or an organization, the prosecution should provide testimony from those who, because they held important positions at the time, they should bring to the chamber people who are actually able to shed light on the reality of what happened in Bangui in 2013. Yet the prosecution has not decided to bring forward such evidence because the prosecution has decided only to call crime-based witnesses, who by definition cannot provide any potentially relevant information about the design or implementation of a possible policy at the highest level of the state or an organization, or insider witnesses, who in actual fact, for the most part, are people who held a lower position within the hierarchy and did not have access to relevant information. The weakness of the prosecution's testimonial evidence is particularly striking because, as we pointed out earlier, the prosecution does have previous statements that could truly shed light upon these issues for the chamber about what really happened at the time. But the prosecution decided not to call these people or to drop other ones between now and the time of the confirmation of charges. What happened to P0238, a witness who logically was chosen for the confirmation of charges hearings because of his direct knowledge of several matters in connection with the allegations of the prosecution concerning the OCRB. But he's been dropped. Whatever happened to P0413? A witness who, logically enough, was chosen for the confirmation of charges hearing because of his unique position to comment upon the disorganization of the Seleka. This witness has been dropped now. What about P0964, a witness who was also in an ideal position to express his views on matters relating to the OCRB? Logically, that witness was chosen for the confirmation of charges hearings, but now has been withdrawn without any reason, taken off the prosecution's list of witnesses. And where is P1019 to be found, who was in a good position to provide unique information about matters at the very heart of the prosecution's allegations because of the role that he played at the time of the events? Why are those witnesses not there? Merely because they contradict the prosecution's narrative at each stage. Here are two examples. In his previous statement, P1019 mentions that the so-called Seleka coalition was very disorganized, even before it entered Bangui in March 2010. He said that there was no coordination and that there were disagreements between the various groups that made up the coalition. He mentioned the security situation in the Central African Republic in 2013. He mentions the support provided by the international community on the 22nd of March 2013. He mentioned the day-to-day criminality that prevailed in Bangui in 2013. He mentioned the actions taken against the various groups that made up the Seleka coalition and its members, for example, the billeting of its former members, group members, who made up the coalition to avoid problems related to crime. These are all issues that should be examined during the trial. Let us now turn to P0234, who provided crucial information about people who claim to be part of the so-called Seleka coalition in the CAR at the time of the events, and crucial information about certain incidents that allegedly occurred at the OCRB. Just because witnesses provide information that contradict the narrative of the prosecution, just because of that, it does have an obligation. The prosecution does have an obligation to bring to the chamber all useful elements to establish the truth, as set out in Article 54(1) of the statute. If the prosecution decides to prosecute a person, they must do so after a full investigation with a clear vision of what happened. Thus, being in a position to identify the people, the perpetrators, without having to manipulate facts or not saying anything about certain events. Otherwise, the prosecution would be making the choice to present the chamber with a misrepresentation of the events, which will necessarily have an impact on the search for truth and the work of the court. The probative weakness of the prosecution's case is surely the reason for the prosecution, ever since the beginning of the trial, engaging in multiple procedural approaches that, if followed, could make the trial opaque and incomprehensible. The prosecution has asked that 60% of its evidence not be discussed in open court with the witnesses, so it will not be possible to have a true debate about the relevance of this evidence. The prosecution has also asked that half of the witnesses not even come before the court, not even appear. In other words, the prosecution is merely asking for their previous statement to be taken at face value, which is the very negation of a judicial process. As for witnesses who will appear, the prosecution would like 60% of them not to be subjected to true cross-examination. In addition to these requests, the prosecution does not want these witnesses to be heard in proper conditions. They have obtained an agreement that the few witnesses who will be heard in a hearing, 75% of them will be heard over video link and not in person, even though many of them can actually appear in person, and 80% will benefit from protective measures that will hide their identity and make them anonymous. Thus, the prosecution is hoping to hide the weakness of its evidence by holding an opaque trial, impossible for external observers to follow. A trial in which evidence is taken at face value and their witnesses will be taken at face value. They will be believed. No adversarial debate. They will testify from the shadows. Weak evidence, not verified, not authenticated, not corroborated, full of non-verified hearsay, evidence that often was not even the outcome of a true investigation. Incomplete evidence because the prosecution did not obtain the useful information from the most important protagonists of the crisis. The evidence is also incomplete because the prosecution has deliberately decided not to call the witnesses who are in the best position to tell the chamber about crucial aspects of their case. The prosecution has decided to go to trial with this unsatisfactory case and is asking, and it will be your task to come to the appropriate conclusions at the outcome of the trial. The case does not allow you in any way, in no way is it possible to demonstrate the charges beyond reasonable doubt. Thank you.
Thank you very much, Mr. Jacobs. Yes, Ms. Nawi.
Merci, Madame la Présidente.
Thank you, Mrs. President. So now we're going to talk about the quality of evidence brought forward by the prosecutions, and we are going to look at the narrative which supports the evidence put forward. Reading the prosecution's brief, we note that the prosecution's narrative has not changed. They have not failed to close the gaping holes in their narrative, which is supposed to allow us to understand the charges and to contextualize the narrative of the witnesses. Why was the prosecution not able to close these gaps in a way in which they could respect the reality since the confirmation of the charges hearing, because on analysis the reality does not fit with its accusations, because they can no longer take a step backwards because it is too advanced, too exposed, so the prosecution no longer has a choice. And it's the reason why the prosecution persists in ignoring decisive facts and leaving temporal and factual holes in its memory. In its brief. When I'm talking about memory, I'm talking about brief, not sort of the memory of something that you recall. Aware of the inadequacy of the brief, the prosecution looks at the vagueness between the different events and protagonists. Aware of the inadequacy of evidence, the prosecution also maintains the vagueness between what happens with the Celica and the others on the state. Why? Because it is not possible to demonstrate the functioning of one or the other. It's therefore up to us to deal with these issues today, to qualify the situation on the ground between April and September 2013 in the Central African Republic, and to understand the role of the state during that very same period, because the legal consequences emanating from this situation, which occurred between April and September 2013, are important as regards the basis for the charges brought forward by the prosecution, be it war crimes or crimes against humanity. The prosecution, in its brief, postulates that, 1, the Celica exists as a clear hierarchical and structural group, paragraph 19, capable of conducting coordinated operations, paragraph 20. And secondly, this structure of Celica is the one that would become the state, paragraph 22 to 29. In reality, as the name suggests, the Celica is a simple coalition, which means that it is a temporary alliance of individuals or groups to give voice to their discontent against President Bozize. This alliance does not mean, in any case, that each of its participants agrees on how to resolve this discontent. Therefore, the coalition does not postulate an organization. We know that the various groups that make up the coalition were created in reaction to the power in place, to allow the existence of a real democratic opposition. The number of groups, and therefore leaders, multiplied from the outset in the years 2000. The prosecution, in presenting its brief, put forward a simplistic view of a group that will form a circumstantial alliance and does not have the specificities or leadership problems. We do not have the time today to develop all the internal struggles and all the contradictions between those claiming the paternity of these different groups, since the saga are complex, convoluted, and numerous. We will show during the trial debate how different these groups are, and that the reality of what these groups cover is constantly changing as the context changes, whether it be political or security. Today we will pick out some examples that reveal the lack of cohesion and homogeneity within these groups. Firstly, the creation of the Democratic Front of the Central African People, the FDPC. The first president of the FDPC was Abdullah Miskin. Abdullah Miskin created the FDPC on the 5th of June 2004 and signed a ceasefire with Bozize government on the 2nd of February 2007. From that moment onwards, the fate of the FDPC fluctuated. Firstly, as the peace agreement, which was not respected by President Bozize, the FDPC launched an attack against FACA, which led to a new agreement on the 3rd of July 2009. Then, the enemies of yesterday became friends of today, because in January 2012, Abdullah Miskin will fight alongside FACA, the forces of President Bozize, against the RPF, the movement of General Baba Lade. This does not, in following on from this, prevent Abdullah Miskin from participating in a meeting in Niamey in 2012 in the presence of Michel Djokovic and Joachim Kokate, who are members of the CPJP. After Niamey, Abdullah Miskin, Michel Djokovic and Joachim Kokate set up FURCA, the United Front for the Renaissance of the Central African Republic, another alliance to fight against President Bozize, which took place in 15th of March 2012. Yet, Joachim Kokate, who left the alliance directly to join President Bozize. Later, in autumn 2012, Abdullah Miskin participated as the UFDR, the CPGP Fundamental, and the CPSK in the creation of the Seleka. It is interesting to note that in March 2013, Abdullah Miskin left the Seleka to fight against it, and that in a communique of September the 10th of 2013, Abdullah Miskin announced that his party, the FDPC, joined the FROCA, Front for the Return to Constitutional Order in the Central African Republic, which is a movement associated with President Bozize. Here we have the perfect example of the opportunism which guided the different factions. Abdullah Miskin changed alliances according to the development of the situation in the Central African Republic. Another example, the UFR, the Union of Republican Forces. Florent Najer presented himself as the leader of the UFR, which he created after having been tortured by President Bozize. He signed the peace agreement of the 15th of December 2008 on behalf of the UFR.
Will get your words. Thank you.
Alors, je reprends.
I'll start again. As regards the Republican forces, and on Florent Najer, who presented himself as the leader of the UFR, which was set up after being arrested and tortured by President Bozize. He signed the Global Peace Agreement in December 2008 on behalf of the UFR. However, the evidence of group is very scant. And the representatives of the DDR, those are the Program of Disarmament, has recognized that this group never really existed. It is a perfect example of an existing group existing only by name and symbolism, and therefore, above all else, it is an attempt by the leader to be recognized in the political landscape. It is interesting to note that we have, as regards the UFR, we have contradictory information or evidence. Some witnesses, like P1019, that the UFR was not part of the Seleka, whereas other sources say that the circumstantial coalition had benefited from intermittent support of the UFR. Another example, the UFDR, the creation of the Union of Democratic Forces. The UFDR is one of the most emblematic groups and would participate in the coalition. But it is also one of the groups where there are numerous contradictions. The UFDR is disorganized as regards the paternity of the group and as regards the members who are always fighting with each other. Let's take an example. A witness, PK 0413, said that the UDFR was set up by De Choja and Damen Zakara in 2006. Other well-informed sources explain that originally the groups composing this union was made up of armed men from rural and non-centralized areas, forging flexible alliances before becoming rebels. Because of the monetary interests, clashes between different groups took place, which led in 2005, the leader of the Gula, Daman Zakaria, made an alliance with Abaka Saboyon, a former liberator who turned against President Bozize. However, as Abaka Sabon is in Cotonou, in fact, it seems that Daman Sakara is the leader of the UFDR. Again, other sources indicate that the UFDR was led by the famous Florent Jader, who claimed responsibility for attacks that took place in 2005 and 2007. It is interesting to note that while Michel de Choja was imprisoned with Abaka Sabon in Benin, Daman Zakaria signed a peace agreement with Bangui in April 2007. Following this, Daman Zakaria was appointed to the government of President Bozize, which Michel Djotoja disapproved of and which led to clashes between rival factions of the UFDR. Michel Djotoja struck Daman Zakaria off the roll in May 2008 and replaced him with Yunus Omar and Joseph Zundeko. It is also interesting to note that shortly after June 2008, Abakar Sabon left the UFDR, of which he was the spokesperson, to take over the MLCJ in 2008 and then continued to change camps or sides many times. These elements clearly demonstrate that within the same group there are strong disagreements and it's almost impossible to establish who was leading the group. The accession to a position of power was remunerative, and so was the purpose of accession. Another example, and the last one we'll do for today, and equally important, it's the penultimate. The creation of the Convention of Patriots for Justice and Peace, the CPJP. The CPJP was never unanimous, and its internal functioning was the center of constant power struggles. PK 0413, in its unique position, states that in 2008, it was Dafan who would have created the Convention of Patriots for Justice and Peace, the CPJP, with Noureddin Adam. More specifically, the CPJP was created by Dafan and Issa Bourma, the uncle of Noureddin Adam. So Dafan would have been the political head of the CPJP, but was not aware that Noureddin and Ali Mahamad Daba and Al-Basha Fadul, whose father is the uncle of Dafan's mother, were organizing fighters on the ground. Other well-informed witnesses indicate that the CPJP was created by Noureddin Adam and Abdullah Hussein, and that it was between these two men that there was a disagreement. Such a disagreement that had led to two wings of the CPJP. And it was only after the death of Charles Massy that Abdul Hussein and Noureddin Adam would come into conflict to be the head of the CPJP. For others, the CPJP would have been created by Charles Massy after having been minister under President Bozize. As for Abdul Hussein, he would have remained in the CPJP to ally himself with President Bozize to fight the Seleka. It is interesting to note that there are indications that the UFDR and the CPJP, although temporarily allied with the Seleka, had long clashes against ethnic tensions between the Gula and Runga for control of territories and resources. Finally, who is Abdul Hissan, Norodom, Adam, Charles Massey, Mohammed Zakaria would have founded the CPJP, and who was the head of it? Who had the capacity to sign agreements on behalf of the CPJP? It's impossible to determine that. Final example, the convention or the creation of the Patriotic Convention of the Salvation of the Kudro, the CPSK. It is Dafan who founded the CPSK in June 2012 after being part of the CPGP. However, others show, particularly P1019, that Dafan was a member personally. His group and the CPSK never existed. This means that Dafan simply was the founder of the CPSK, where the others say that he never set up the CPSK and that in his personal capacity created the UFDR. For others, Dafan simply coordinated the actions of the foreign companions of Bouzize who were fleeing and the UFDR. Be it as it may, the internal power struggles between Mohamed Moussa Dafan, Michael Jotutia, Noureddin Adam, Abdullah Hissène, Mohammed Zakaria, Charles Massey, and more, created strange and amusing situations difficult to follow that continue even after March 2013 and the dissolution of the Seleka. The prosecution says as if the different groups were clearly defined and had the capability of coordinating themselves. But nothing is further away from the truth. Why does the prosecution not mention that the CPJP was created separately from the UDPR? And from the outset, there were struggles to be head of that group. On analysis, it appears that these groups are disparate and that there is a differences between the different groups so that they don't coexist peacefully, internally and externally. And in addition to that, there is the struggle for the legitimacy of being recognized as a legitimate opponent to the government in place, preventing thereby any form of coordination. The only cause that brings them together in an ephemeral way is their dissatisfaction vis-à-vis President Bouzize. It's a randomly made up coalition, sometimes regarded as a regional movement. For example, Roland Marshall, researcher of the series Sciences Po, specialist recognized in France, specialist in Central African Republic, says that the Seleka was nothing else but a federation of armed groups, themselves weakly structured without a real chain of command. Therefore, there is no hierarchy between the groups. The elements composing the different groups are scattered in different areas or indeed in different movements, and are insufficient in number. It appears that in reality, the coalition was created only to participate in the Libreville summit of January 2013. Why? Because it was a way of fighting against the government of President Bouzize. In February 2013, 1 month before the Libreville agreement, President Bouzize announced during a ceremony to celebrate his 10 years in power that he would be a new candidate for the future elections, which is a breach of the Libreville agreement. Furthermore, the prosecution puts forward as a postulate that what they call Seleka managed to get to Bangui. This would be evidence that the Seleka would be able to organize itself. This attempt at explanation a posteriori does not stand up to analysis. The evidence to which the prosecution has access shows that nothing in the arrival in Bangui was coordinated, nor organized, nor planned. The evidence is clear. Those who are supposed, according to the prosecution, to be the thinking heads of the Seleka and to be those giving orders who were taken hostage in Bambari by the elements of the UFDR. In the days preceding the descent to Bangui, this thinking head was kept incommunicado, and the so-called commanders learned on the radio that groups making up the Seleka were heading towards the Red Line, and therefore they were heading towards Bangui. It is not clear who would have given any orders or commands. A well-informed witness, 1019, says clearly, what happened between the international community and the Seleka, only God knows what happened. In such a context, which is difficult to imagine, what sort of chain of command could really exist? P1019 said that President Duterte was not aware of the military chain of command because he only arrived in Bangui. Only the groups composing of the Seleka alliance had arrived there. And he was not aware of what happened before he entered Bangui. The prosecution prefers to ignore the testimony, although from well-informed sources, and states in its brief that the capture of Bangui in March 2013 was carefully planned by high-ranking Seleka commanders, including Jotodia and Adam, paragraph 21. By basing on footnotes of insiders who in reality are only subordinates based on hearsay and therefore not in a position to give any useful evidence for such a statement.
Une fois des groupes composant la Seleka,
Once the groups making up the Seleka arrived in Bangui, that is when Michel Jotodia finally went from Sibut to Bangui in the afternoon of 23 March 2013. It's important to note that the day before, Michel Jotodia received support from international stakeholders, including support from the French ambassador, who even had found a residence for him. on the 24th of March 2013, Michel Djotodia proclaimed himself to be President of the Republic, and the situation quickly became official and led to the creation of the National Transition Council on 13 April 2013. By the 31st of March 2013, President Djotodia had appointed a national unity government. This national unity government was made up of 34 ministers. And we make reference to CAR OTP 2004-1597. This is the official decree. Of these 34 ministers, only 9 were officially affiliated with the Seleka. And yet the prosecution focuses only on the appointment of these members from this old alliance known as the Seleka. If we analyze the elements that the prosecution themselves have provided to support this statement, it clearly appears that this is a national unity government that was constituted in compliance with the Constitution and the Libreville Agreements of 11 January 2013 with Nicolas Tianguet as Prime Minister. P0291, a prosecution witness, has stated that, quote, all the groups that took part in the Libreville Summit were represented within the transitional government, including ministers from the former Bozizé regime. In accordance with the presidential decree, a number of prominent people with the profile of experts in their field were also part of the government, as well as several representatives from civil society. For example, Arsène Sendé, a judge who became Minister of Justice, Charles Armel Duban, the former ambassador of the Central African Republic to the United Nations, who became Minister of Foreign Affairs. Under these circumstances, talking about a so-called Seleka government in no way corresponds to the reality. As for the National Security Council mentioned yesterday, once again, the prosecution is doing the same thing. They only mention that Noureddin Adam and other Seleka commanders, that's all they talk about, but they omit to mention that Presidential Decree 13.185 found in its brief that this council, this National Council of Security, was made up of numerous ministers representing people from various groups or of various affiliations. Of these 13 positions, only 3 were held by former Seleka members. What the prosecution is not telling you is that the Comforce of the FOMAC, the defense attaché of the French embassy, and the representative mediator responsible for resolution of the crisis in Central African Republic also were on this committee on an advisory basis, as if the prosecution is disregarding the security context that existed in Bangui when this council was established and during the entire presidency of Michel Djotodia. And now, a few words about the Council of Ministers. President Djotodia never denied the Security Council context that prevailed in March 2013. He never denied that the situation was difficult, and as soon as he accepted his duties, he began to deal with the bandits. Similarly, both President Pretoria and Prime Minister Tiangai spoke publicly, saying that the elements who said that they were part of the former Seleka should be put in one area or restrained so as to avoid problems of crime. It should be noted as well that often people said that they were part of the former Seleka, hoping to gain some benefit from their membership. So, Prime Ministers, or rather the Prime Minister said to those bandits, come and stay in this area, we will avoid problems of crime. In some cases, people passed themselves off as members of the Seleka, people who actually were looters, and the government tried to restrain them to one area, keep them in one area, so as to halt these elements who suddenly said, all of a sudden, that they were members of the Seleka. As P0234 said, a witness dropped by the prosecution, people who, these people who were no goods, thugs, would come together and claim that they were Seleka members. President Pretoria decided to attempt to disarm the elements of the Seleka coalition. Once a national transitional government was established, it was the government, I stress, it was the government that took measures to deal with the danger prevailing and adopted a strategy to ensure the security and safety of the Central African Republic, which involved, and I quote, disarm the elements of the Seleka coalition. And I am quoting from CAR OTP 2034-2193 at page 2194. This same document,
Ce même document
indicates that several radio bulletins broadcast over the radio calling the former Seleka rebels to order and asking them to identify themselves for possible sending to barracks, to be possibly sent to barracks. This calls were made by the Minister of Security, Immigration, Emigration and Public Order. For example, in a press release dated 3 April 2012, the Minister of State responsible for security, Nourine Adam, was issued, and he requested, and I quote, officially and on an urgent basis, I call upon all Seleka elements, without any exception, to return to their various camps chosen for their restriction to barracks without delay. He made this request formally, officially. Upon the threat of punishment, the Minister of Security formally recommended, and I quote, he said, to other elements who are out of control, people who had weapons, profiteers, and people who were taking advantage of the situation and still engaging in looting, vandalism, and other acts of violence and abuse, to immediately stop doing so throughout the entire territory of the Central African Republic. End of quote. P2328 has described the cooperation between the transitional government and the local UN office to keep Seleka elements in one area, and I quote, "But with the local UN office, we made suggestions to restrict Seleka elements to one area because at this time in the Central African Republic, there was only Seleka members and FACA members. Thus, we grouped the new Seleka recruits in Beringo, in Beal camp, in Camp RDOT, and towards PK12. We grouped them in these various areas so that we could do a census of them, but it was very difficult work." In May 2013, the Prime Minister announced that a number of combatants who were en divagation, be they from the Seleka or former FACA members, were not authorized to hold weapons and were to hand them over as quickly as possible before being barracked outside of Bangui. In August 2013, President Jojodia met with neighborhood leaders to organize disarmament in the various arrondissements of Bangui and to condemn the violence and the lack of security. In particular, the prosecution ignores that the looters and the Seleka looters and delinquents were being prosecuted, particularly for the events in Boirab. This prosecution was covered by the media and documented by NGOs, and also are mentioned in the statements of former prosecution witnesses who were, in particular, P0234. In actual fact, the prosecution has material, concrete, and official elements that attest to these proceedings, 24 statements that yet have been completely ignored by the prosecution. Each time that the reality does not square with its account, the prosecution merely ignores it. So the state had no impact on the various groups in Bangui. No impact. More specifically, an expert who was commissioned by the prosecution in the Yekatom and Ingasona case said, and I quote, "The Seleka was a coalition brought together by circumstances, a coalition of armed groups. The reality of power was not to be found in the government of Michel Djokoda Nicolas Tiangai, but rather amongst the power was with the commanders. Amongst them, the hierarchy and discipline were almost non-existent. On the one hand, the Seleka was impossible to govern because of its lack of internal discipline. On the other hand, it was not able to govern because the armed groups that made up the Seleka had only one goal, namely to bring down President Bozizé, and did not have capable managers who could run the country. Barely functional, the government did not have authority over Seleka commanders. Even the political representatives of the Seleka had no influence over commanders. And amongst themselves, they barely obeyed one another. The various armed groups only recognized only the authority of their direct leaders. And this is evidence from the prosecution, CAR OTP 21274289. Roland Marshall, who was mentioned today, has explained this about the Seleka. Quote, there never was any true control at the political level. It was rather a federation of armed groups that themselves were poorly structured without a true chain of command. End of quote. Similarly, Clotaire Soleil Surungba has said clearly, and I quote, on the other hand, it is an easy matter to say forcefully that between the 24th of March 2013, the Seleka warlords and the President of the Republic, Michel Dochorio, lost control over their men, both in Bangui and within the interior of the country. End of quote. He also explained that the so-called ranks of the various people were self-attributed. And I quote what he said. Quote, Seleka combatants did not recognize any hierarchical authority, and their, quote, military culture, unquote, was such that they preferred ranks such as captain, colonel, and general, which they would grant to one another. He also told us, and just imagine this, you might see a colonel sitting behind in the back of a pickup with a captain who is sitting comfortably in the passenger seat, and the vehicle is actually being driven by a general. Witness P0234, a witness in the know, dropped by the prosecution, said this, quote, around August 2013, there really was a government problem. There were several parallel chains of command. There was no control. Nearly all the Seleka were colonels or generals. I can describe the situation as a kind of a widespread form of disobedience with a strong taste for military stripes. Giving testimony before the American Congress, one expert said, and I quote, there has never been much internal cohesion within the Seleka movement. The Seleka was born of a coalition of combatants from rebel groups that had existed for a long time and that historically were opposed to one another. The coalition was always full of conflict. There were only troops loyal to individual commanders with a very weak hierarchy. There was no agenda, no ideology, no consistent political platform behind the Seleka movement, with the exception of a general feeling that the north of the country had historically been neglected. Prosecution witness P0291 himself said that the Prime Minister himself stated that President Georgia was not capable of controlling the country or the situation, the security situation. The various Seleka groups listened only to their own leaders. The UN summed up the general situation quite well, this atmosphere of widespread chaos, and I quote, "The Seleka has revealed itself to be more of a composition of blocs looking out for their individual interests, trying to find personal resources rather than a government with a clear political agenda. Getting Bozizé out of power seems to be the only strategy that unified the former rebel groups. The Seleka remains a non-homogeneous entity with soldiers who take instructions from their own commanders." Finally, the Secretary General of the United Nations noted in May 2013 that dissent has increased within the coalition and the leaders are having difficulty controlling their own elements. There was no control over the Seleka elements. He continued on and said this: "The Seleka combatants refused to be restricted to one area. Furthermore, the tension amongst the various factions within the coalition, it continues, and each person is trying to recruit more elements, which increases the risk of a widespread confrontation amongst themselves." And now, just a word or two about the CME. Correction, the OCRB. Apologies from the interpreter. The prosecution has said that the OCRB was apparently a Seleka base. What we see from the available information is that the OCRB is an office that existed before the government of President Jotobia. It was part of the state structure, and it continued to fight crime despite the difficult circumstances. This morning, we reminded the Chamber that ever since the 18th of April 2013, the OCRB was led by General Louis Mazengi, as we see in a memorandum number 135. And later, this gentleman was replaced on the 8th of July 2013 by Benjamin Malo. The OCRB was put under the authority of the Central African Police Directorate, which in turn was part of the Ministry of Security. The OCRB was first and foremost a police station that was part of the state structure, a police station that had to continue its operations during a period of high crime and delinquency. Furthermore, the memoranda and the decrees published in the official journal show that the various appointments of officials show that the state continued its attempts to operate. I can see that the time is fleeting. I am about to move on to another topic. Perhaps this would be the right time to have our lunch break.
Right time indeed. Well, we'll break off for now and come back at 2:30, Ms. Nauri, so that you can continue and hopefully finish off. Thank you very much. Madam Kotofisa, we'll go away and come back at 2:30, please. Thank you.
All rise, we have 11.